Welcome. I'm Mary White, and I am delighted to talk to you today about intellectual property as part of the Student Enterprise Programme. This is Ireland's biggest and most successful initiative for young entrepreneurs. Throughout this journey, you'll learn real-life business skills and discover what it's like to be your own boss. You'll build creativity, communication, resilience, and teamwork, skills that can serve you for life. You might even uncover a future career in marketing, sales, product design, fashion, art, or engineering. There's also the chance to earn money, showcase your ideas, get expert feedback, and compete for awards at county and national level. For teachers, the programme offers fantastic resources that can inspire and support the next generation of innovators. My talk is all about protecting the value of your ideas through intellectual property, and to help you learn about intellectual property rights, such as trademarks, patents, designs and copyright, and to see how these might relate to your mini business. Some of you might already have business ideas, others could still be exploring. Brainstorm freely because your first idea might not be the best. Think about what you love and think about how you can improve it. Or else consider a problem in the world, something that perhaps you could solve. If you're still in need of inspiration, check out the website and see what past winners have done. Just remember that even the silliest idea could have serious potential, so let your imagination run wild. When you have brainstormed ideas, do a little research into your market. For example, if you're thinking of making a chocolate product, search how many people in Ireland buy chocolate each week, and you could see just how surprisingly big your target market is. Then, before you launch, think through some of the practicalities, what you'll need, the possible costs, and the challenges that you might face. If you ever think about questions like, well, what materials and resources will I need? Can I source them affordably? Are there any safety or hygiene rules that I would need to consider that would apply to what you're making? A key aspect of enjoying the Student Enterprise Programme is to enjoy adapting. So if at first you don't succeed, don't give up, just make a change. One thing to consider is, well, what happens if your business takes off? Could you scale up or get help? And then importantly, well, what would happen if your business is so successful that somebody else wants to copy your idea? This is where we turn to protecting the value of your ideas, understanding intellectual property and how it applies. The clue is in the name property. It's about ownership of what your imagination or intellect has created. So IP can help ensure that the benefits of your hard work comes back to you. Intellectual property builds value, and big companies spend heavily to protect their names and logos because those assets are so valuable. If we think of, for example, Captain America or Spider-Man, these aren't just characters in a comic. No, they are protected names, and they have protected images which power huge industries, selling millions of cinema tickets and lots of toys and clothes and games. The same goes for famous brands such as Ryanair, Levi's or Louis Vuitton. Brands can invest a lot of money in terms of safeguarding their brands worldwide. So, what could you own? As you develop your business ideas, it's possible to design your products with intellectual property in mind. It's important to think about what you can own and what maybe can't be owned or monopolized by any one business. There are certain common or generic aspects of products that no one business can claim to be theirs. For example, here we have competitor products that are both in clear plastic bottles. And obviously, we can't say that any one company is the exclusive owner of clear plastic bottles. However, you can see that these products have different names put on them, and those names are unique and protected, so they can't just be copied. If you look a little more closely at the packaging, you'll also see that they have similar pictures, but they're not identical. If they had been identical, then one might have infringed on the copyright of the other. So they can both use the idea of oranges and of barley in a meadow, or leaves and a sense of nature. There are certain concepts that can be shared, but the actual expression, the specific imagery, cannot be a carbon copy. So how close we can come to other people's businesses, it can be a fine line between drawing inspiration and copying. There are different kinds of intellectual property rights which protect different aspects of businesses. So if you're creating an invention, like a new technology, or a new, say, engineering problem being solved, then it could be a case that you have come up with an invention that is new and novel, and which goes beyond that which was the state of the art before. And in that case, you might have a patentable invention on your hands. Patents can be really valuable, so it is worth exploring whether you might actually have a patentable idea. It's also really important to make sure that you're not using somebody else's technology that's already patented without your knowledge and without investigating whether you would have permission to use that technology or not. So scoping out patents is a little bit tricky because they are quite technically written documents. So I would suggest it's a good idea to talk to an IP attorney if you feel you might be in the position that you have a new piece of technology or a new invention. And I think it's a really good idea to have that conversation early, because patents need to be applied for at an early stage before they go out into the public domain. So if you bring along your invention to the national final and show it off in front of all of the people who are there on that day, that would be a disclosure of your invention, and it might rule out your ability to get a patent at a later date. So it's really important to get advice on patents as early as possible. A second kind of IP right, and one which will apply to a great many of your businesses, is copyright. Copyright protects new works of art, and it doesn't have to be a Mona Lisa to constitute a new work of art. Artwork can be a new piece of music, some new recorded content, maybe a new story you've written. It could even be an instruction manual for how to use your product. So there are a lot of different types of new content that automatically avail of copyright protection. It's a really good idea for you to keep notes of your creative process so that you can show that you are the author of your new work, and also date it. File metadata can be helpful in this regard. So if you take a new photograph, your file on your telephone, in the camera roll, will actually have metadata associated with it, which will show the device on which the photograph was taken and the date and the time and so on. And if you're working on your own creative process at home, make sure to keep some kind of a diary or log of what you did and when, in order to prove your copyright exists from a particular date. A third area of IP rights that might apply for some of your businesses is designs. So when you create a new design, that's the aesthetic appearance of a product, the shape, the contours, the colours, the design of the product might be valuable in itself. And in that event, the great news is you would be able to avail of up to 3 years of unregistered design protection. So you don't have to pay for it, just like copyright, it's free. And an unregistered design right will be available to you for up to 3 years after you disclose that design. It's possible for people to register their designs, and that would allow them to extend the life of protection for that design for up to 25 years in total in the EU. So that also makes it easier to enforce those rights when you have them registered. But for the purposes of this entrepreneurial program, a great many of you will be able to advise the judges that you know that you have unregistered design rights in particular products that you are making. So hopefully that is a second type of IP right that's available and that you can avail of without having to pay money or avail of particularly tricky procedures or anything. Nothing needs to be done. Then the fourth type of IP right, which is really important for many businesses, and I'm sure that this will apply for nearly all of you, if not every single one, doing the Student Enterprise Programme, because all of you are going to give your business some kind of a name. So trademarks are the IP right that best fits brand names, company names, product names, and also slogans and logos, and perhaps even colours. So sometimes businesses have been able to register particular colours like Tiffany blue for jewellery, and the special purple red colour for Victorinox Swiss Army knives. So there are colours which have been trademarked in respect of particular products. Now it's actually quite tricky to convince the Intellectual Property Office that your product is the only product that's connected with a particular colour. So for example, it would be very difficult to associate red with t-shirts of a particular brand, because lots of brands already make red t-shirts. But trademarks really are a wonderful and versatile way of protecting many things that act as symbols of a business. And one of the great things about trademarks is that they can be renewed again and again and again. So unlike any other form of IP right, trademarks can last indefinitely long. And that's one of the reasons why they're so very robust and useful for brands who want to have long-term value in the work that they create. Now, we talked a little bit about works that are in the public domain, ideas basically that you cannot protect. So aside from things that are common or generic, like plain English words, it turns out that if your idea is already out there in the market, it can be tricky then to try to claim a monopoly right over it. So for example, if your idea turns out already to have been invented, well then it would be difficult to get a patent for that. If I have a slogan or a name that's purely descriptive or purely laudatory, like Dublin's greatest bakery or Galway's best fish shop or whatever, those types of names typically are not capable of acting as a trademark. In fact, if a trademark application is found to be fraudulent, it won't be allowed either. If I apply for a name like 100 wool, but my products are made of cotton, I'm not going to be allowed to have that trademark because it implies that it's made 100% of wool. It's suggestive of that, and it would mislead consumers if I was to have a trademark that pointed them in clearly a false direction. So trademarks that are purely descriptive or deceptive or merely laudatory typically will not be granted. And designs that already exist in the world, obviously, if they're not novel, they can't be registered legitimately. So designs that are already out there cannot be protected for a second time by a new entity. And that means things like a plain white t-shirt or a grey hoodie, unless there's some feature that's new and novel and exciting. So there has to be something special about it for it to be able to qualify for design protection. So let me give you an example and you can have a think for yourself. If you were a trademark examiner and someone came along and said, I'd like to register the name Extra for chewing gum, do you think that would be allowed? Well, the EU Intellectual Property Office said no and refused to give a trademark for the name Extra for chewing gum because it's quite a common word. This shows why it's important to pick names that really stand out from the crowd, because extra could just mean extra peppermint, extra flavourful. It was too vague and too general, and it really couldn't be monopolised by any one company, because it was believed that it was simply a word that meant more than is usual. So let's have a look at something that could be protected. Here's a design right for a perfume bottle that Giorgio Armani's company in Italy filed before the EU Intellectual Property Office. They filed pictures of the bottle from different angles, and they filed for line drawings to show off the shape, and then with photographs to show off the colour. Finally, they applied the actual name of the perfume as a trademark. So My Way is a registered trademark, as indeed is Giorgio Armani. So by layering design protection for the shape of the perfume bottle, the colour of the unusual cap, and then adding the trademarks for the name of the product and the name of the brand, they have 4 layers of intellectual property protection just on this one product to keep it from being copied by other people. Let's have a look at another example. So this is an older PlayStation controller, one that was protected by a design. Now there are many different types of PlayStation controllers that have been protected by Sony, and in fact it makes it very difficult for competitors to create a controller that looks anything like it. The PlayStation controllers are also protected using a number of patents, and the patents are looking at technical features such as the DualShock shake or the noise coming out of the controller and so on. So there are different patents that protect how it works. The design protects how it looks. And then of course we have the brand name as well, PlayStation, which is an EU trademark. So again, a good example of a common everyday product that is protected by several different types of IP altogether. So I just want to turn to a couple of kind of interesting areas around IP that might be relevant in our everyday lives. One thing is, I suppose, the issue of counterfeits. So about 5% of products that are coming into the EU are fake, copies of other products that are legitimate. Counterfeit products can be quite dangerous. So, for example, a fake phone charger that could break or which causes a fire. Our Irish customs work hard to stop such fakes and to keep us safe. A slightly different aspect of copying than in this slide, we're looking at dupes. So counterfeits are products that are pretending to be somebody else. Dupes are not trying to fool us into thinking that they're exactly the same product from the same origin, but what they are doing is leading us to believe that they're a cheaper or different version of a very similar product. So there's a big difference between counterfeits and dupes. So we often think of both counterfeits and dupes in regards to fashion. We think of, counterfeit sunglasses maybe being sold under the Eiffel Tower or whatever, and we don't necessarily think of them as being as dangerous as they might be if it was a food or a medicine or a protein powder for the gym. So very often counterfeit products are not what we expect. Dupes, on the other hand, I think are now a part of mainstream life. But it is important if you're creating a product that you realise how far you can approach the look and feel of another brand. And you need to also ask yourself, is that really helpful? Does that help me stand out, or does it just make me look more like one of the same? So it's really common now for cheap brands in supermarkets, for example, to work to actually look a little bit like key competitors, big brands that have invested in their packaging. And it might seem somewhat fair or maybe somewhat unfair. I'd love to hear your take on that because everybody's view is a little bit different. If we look at these examples, you can see that the colours used on the packagings are kind of similar, but they are falling into that type of area that we would say they're in the public domain. I can't stop people having a blue sky in the back of their packaging, and I can't really stop people from using ordinary words like anti-wrinkle on packaging for a face cream. So these are where brands are deliberately positioning themselves and using all of those publicly available features, ones that are not protected by IP, in order to create a product that looks like another one. But what happens if the similarities become too great and they cause consumer confusion? And this can happen quite easily, and it can land you in a lot of hot water. So there is a fine line between drawing inspiration and copying. And if you are found to have copied somebody else, then you might be infringing on their intellectual property rights and be legally liable. So there's a lot of litigation, and you can read about it on Google or through any of the news outlets about cases that are ongoing, fights between one company and the next over whether or not their brands are too similar, or whether or not a product is a copy of somebody else's product. And you can see that sometimes there are big damages awards when a company is found to have infringed. So my advice for anyone who's creating their own brand, and I say this as part of my everyday job, is always try and be original. It's great to know what your competitors are doing, but it's much better to try to create your own look and feel. Because if you're simply creating a dupe, then all that'll happen is your product will probably look inferior and look like a cheaper copy. And you have the potential risk that you would infringe on somebody else's rights. So, best avoid it for the sake of the Student Enterprise Programme. A couple of other very basic suggestions for everybody here to avail of copyright. I think it's a really good idea that you keep notes and records of your work, and be careful if you're using AI tools to help you create things. You need to maybe check and see, because if the AI tool you're using has rules about ownership, you might find that you cannot actually own what you come out with at the end of the day. It may not even qualify for copyright if it's AI generated, because it may be a computer and not you that is considered the creator of the work. And a computer cannot be an author in the same sense as a human being. Once you have created your work, mark it with the C in a circle symbol to show that it's copyright, and put down your name and the date on which you created it. Practical steps for creating a brand. Well, like I say, maybe try and avoid being a dupe. Try and pick a name and a logo that will fit your business and something that people will recognize and remember. But do try to have something unusual and avoid common or plain names, especially if you want to protect them going forwards. It's a great idea to use your name a lot. You don't need to have 23 different names, just one. It can be very important as well to check the trademark register to make sure that nobody else is using exactly the same words or logo. I'm going to show you a very helpful website, which is called TMView. If you go to Google and put in the words TMView, you will very easily be brought to this screen. So TMView is a free online tool where you can type in the trademark name that you're interested in and then click search, and immediately the product will start to bring you up whatever is the closest matches. So you will see maybe there could be one name similar, or 20 names similar, or 200 names similar. If you click on the advanced search, you can also filter down some of those parameters to make it easier to find the relevant ones. So you can actually choose just the territories that you're interested in for your business, which was probably just Ireland. You can also upload pictures by dropping it or uploading it from your computer, and that'll help you see if anyone has a similar logo. You will find that very often TMView will bring up the closest results, and with images in particular, you might be thinking, well, it's not that close. So you do have to actually apply a little bit of your own judgment to the situation. If you start getting identical results, especially within Ireland or at the EU level, because Ireland is a member of the EU, then I would take that as a little bit of a red flag and say, well, now, it may not be a great thing for me to have exactly the same name as somebody else. You can take that search a little step further by looking to see what the trademark is for. So, for example, if you find a company that manufactures cars that has a similar name to yours, well, that's not a problem if you're selling chocolate bars, because cars and chocolate are not going to be confused by consumers. So if the goods and services that you're selling are really different than the other brand owner's protected goods and services, then there may not be a worrying overlap. So TMView is a free online tool. Have a play with it and enjoy getting to use it, because it really is a very simple to work tool, but full of really useful information when you're doing this project. So that's it. It's a little note to say thank you so much for your attention and for having gone through this little topic of intellectual property with me. Starting a business is an exciting challenge, but your idea could become the next great Irish success story. Don't hesitate to reach out to the Student Enterprise Programme or myself or the SEP coordinator if you need further advice. Remember, this process ought to be fun, and the very best of luck to all of you taking part.